firm of London solicitors has sent out 1,700 letters telling people to pay hundreds of pounds in compensation for illegally copying computer games. The firm has another 5,000 letters ready to send out after going to the High Court, armed with evidence from a company of investigators and internet providers. Cameron Wilkie has had one of these letters.
On the 8th of May, I received a letter from a firm of lawyers called ACS Law, alleging that I've infringed on copyright of a work called Two Worlds. It's a computer game made by Reality Pump, a Polish software company. After about 4 hours of searching the internet and trying to calm down, I managed to find a lot of information, found that they were sending thousands of these letters out and asking for a very, very large sum of money.
How much did your letter ask you to pay?
£655.
Do you play computer games?
Oh, a lot, absolutely. Yeah, I'm a gamer.
Have you ever used your computer and your internet connection to copy a computer game?
No, I deny all allegations under the Copyright Act. I've never used my connection for such. I've never allowed anyone else or authorised anyone else to use my connection for such.
Would you be prepared to hand over your computer and have it examined by a professional?
I would, so long as they were quick about it, because I like to use it for other things. The only problem with that is that because this claim comes from so long ago, this is the allegation they refer to was from February 2008. I don't have the hard drive that I had then. I don't even have the computer I had then. So it would be utterly pointless.
What happened to the hard drive of your old computer?
Well, it died, as hard drives do.
And then what did you do with it?
I threw it out. Not good for anything after that, unless you need a new doorstop. So I bought a new computer. It only costs £100 or £200 these days, and carried on.
But you'd be happy for somebody to come in and examine that computer and look at how far the files go back and make sure that what you're saying is the truth?
Well, that's no problem at all, yeah.
Have you written to them and said that you're innocent?
No, because it's such a spurious claim. I didn't want to have to deny it. In fact, I would love for them to take me to court so the whole thing can be disproved and put an end to all of this.
Cameron Wilkie, well, the firm of solicitors who sent that letter is called ACS Law, and Andrew Crossley runs it. He's here. Who are your clients?
We have several clients, Winifred. They are a variety of copyright owners. They include companies that produce games, films, music, and so on and so forth. And our list of clients is growing.
And how are you gathering this evidence?
We gather it by utilising technical support of a data supplier. The data supplier interrogates file sharing networks. It actually monitors what the file sharing networks are doing.
So for those like me who are not in the know about this, there are places you can go if you want to illegally copy a computer game.
Yes.
Your investigators monitor those sites.
Yes, exactly
okay.
that.
I'm with you thus far.
And the way a file sharing network works is that people join the file sharing network, and it's free to join these networks. They ordinarily would supply a small patch of software onto someone's computer to enable people to download games, but it also entitles people to make available for upload games that are on their software and music and films, and we identify and require IP addresses of the people who are uploading the copyrighted material that we're interested in.
So your investigators get the address and then they take it to the internet provider and they match that address with an individual?
They do. There's another stage in that procedure, Winifred. What we have to do is we receive the IP addresses of what we believe are identified infringers of our client's copyright. We bundle that together and take that to court and make an application. The application we make to court is called a Norwich Pharmacal application. That is an application whereby we go to court and say, we have got evidence that our client's copyright has been infringed and our client has suffered loss and damage as a result. What we don't have is the names and address of the individual IP addresses. However, the ISP, internet service providers who do hold those names and addresses, we ask the court to make an order for compelling them to provide that information to us, and they do.
So what kind of response have you had? You sent out 1,700, you got 5,000 ready. What proportion of those people who get one of these letters, as we heard that Mr. Wilkie do, pay up?
Well, that's a moving target, and it varies from product to product, but it can range from between 15% to up to 40% recovery.
Well, Conrad Murray runs Law Answers. It's a website offering free legal advice, and he's been contacted by some of the people who've received the letters we're talking about. We have spoken to individuals, Mr. Murray, who've had one of these letters and have paid up because they admit they've done it. They've said to us they've done it. What advice are you giving the people who contact you?
Well, the problem is that the actual detection system that's used, which is used comes from a company called Logistep, is probably unreliable. There's all sorts of methods for spoofing IPs, that's the web address, and also for breaking in through Wi-Fi protocols and everything else. In fact, in Germany, a criminal investigator started investigating this on behalf of the German courts, and they ruled it was inadmissible. The German courts effectively threw it out, saying that the evidence they had was no better than hearsay.
Sorry, what are you talking about there? Similar cases to this, but in Germany?
Yes, there were German criminal investigations, and they are basically applied to the provider of the technology, Logistep, and they refused to provide any detail of how it gathered the information. So the German courts refused to admit it.
And you're suggesting then that if similar evidence was presented in court here, that these letters would not then stand up? They wouldn't be.
They may be unreliable. I'm not saying that in all cases. Obviously, there are people that are downloading games illegally, and everybody knows that. But we've had cases, for example, in Northern Ireland. We had a couple who contacted us that were accused by a previous firm, actually, to ACS, of downloading gay porn, and they didn't even have a torrent client. They didn't know what a BitTorrent was. They had no idea about the technology.
What's a torrent client? Sorry.
A torrent client's the actual method of downloading the equipment,
so it couldn't have been them.
The games. It couldn't have been them.
If you're innocent, are you advising people to just ignore these letters?
I think they should respond to them and just basically to treat them as speculative invoicing, which is in fact what this is. There may be evidence against them, in which case, that may be better offer than they would get offered by the court. But if they didn't download it, and your previous person, the person concerned who was on before, said he hadn't, then, basically take them on.
Andrew Crossley, just speculative invoicing, no more than that.
It's absolutely not that. This is a very carefully thought through process.
Ever taken anyone to court?
My own firm has not. The previous firm that was dealing with this, Davenport Lyons, has done, and I believe is continuing that process.
Because our information is that the only people who've ever had to pay anything are people who just didn't respond even to court summonses and didn't turn up, and therefore were just ordered to pay by default.
Again, that's not entirely fair. I know that there are at least one or two cases that have actually been tested to the extent that a default judgment was entered and then an application to set aside that judgment was made, and that application would have taken the form of a hearing, if you like, to determine the credibility of that claim. And if I can come back on the 2 points that...
Very, very briefly, if you would.
Very briefly, the point that Conrad made about spoofing is a non-point for us, because we actually take direct information that overrides any spoofing arguments. And in terms of it being speculative invoicing, all we're doing is putting these people on notice that their IP address is being utilised, and we offer a compromise. They're under no obligation to pay it, but if they ignore us, we will be taking further action.
Andrew Crossley, Conrad Murray, thank you both. The time now, 12:30. You're listening to